So both sides will have 15 minutes to argue the appellee, since there's two of you who divided your time. So each side will have 15 minutes, and then the appellant may reserve 5 minutes. And we're ready to proceed.
Thank you. Good morning, Your Honors. May it please the Court. My name is Attorney Connie Hightower. I represent the appellant in this action, who is the defendant in the trial court action. At this time, I'd like to reserve 5 minutes for rebuttal.
Thank you.
Your Honors, a brief statement of the facts. I recognize that this case has had some complexities, and that there's a lot of facts, and it's very fact-intensive. But the most important facts, I believe, are that at the culmination of this case, there was a trial that was set for December 4th, 2017. At that trial, the parties in this case, not going to trial, the judge decided that they would engage in settlement negotiations. This particular action involves a family company where two of the members who are sisters, everybody involved are siblings, two of the members who are sisters filed for a dissolution of the family company Sums, which was originally put together by their father, created and organized under an operating agreement in 2004, where he also then included his 6 children. There was a counterclaim that was filed in this action, and that counterclaim was filed against against the 2 membered sisters who were the plaintiffs that were seeking relief as to using their likeness and their trade names. This particular settlement conference that occurred, and I say settlement conference, although it was set for trial, on the 6th, there was a purported settlement that was put onto the record. Shortly thereafter, defendants' counsel or Sums' counsel had filed documents so that we would reactivate the case, take it off of inactive docket, as to there not being a purported settlement agreement on December 6, 2017. There were various reasons that were filed in that. Namely, there was some duress that was involved. There was the incapacity of the manager, Christopher Santomauro, who was the manager of Sums, and also one of the siblings, as well as some of the terms that were included on the record were not a meeting of the minds. After that, I think that the court is able to see from the briefs that the parties had briefed whether or not this should return to active docket. I think of a few things that I want to point out. First, we do have 4 assignments of errors on this case. The first assignment deals with the enforceability of the settlement agreement. The second deals with the manager lacking the authority to enter into the agreement. Third is altering material terms of the agreement. And fourth is the abuse of discretion by the court as to the proposed terms in the settlement agreement as to added terms. I'm going to skip really quickly to what we have addressed under point 4. I think that's the quickest and easiest to address. During this case, even after there were hearings held and there were briefs that were done to say that the material terms, there was no meeting of minds as to the material terms. In addition to there being ambiguity, there were proposed orders that were offered by the plaintiffs, and the defendants had objected on the record. That occurred 3 times. The defendants objected to those proposed orders. First, there was one submitted on January 25th that they objected to as there were additional terms. Another one on February 5th as there were additional terms. Another objection which occurred just after the proposed entry submitted on April 10th, which there were additional terms. Those additional terms have been, if you will, the bane of the existence, because there are rentals that were included in the agreed entry that was never negotiated. Under assignment 4, we argue that that's a violation of their due process right. In addition, there was no holding of the hearing on those terms, and in addition, that would constitute there's no meeting of the minds as to additional terms being added. Now, to turn back to the December 6, 2017 purported agreement, there were many things that occurred on that day. The court had indicated that they felt that defendant's attorney had been cloaked with authority. However, that's problematic for a few reasons. There's an operating agreement, an LLC, that outlines what the manager's authority is. There's also Ohio Revised Code, the Limited Liability Company Act, which also outlines what a manager or how things can be done in terms of an LLC. The fact that the agreement that was placed on the record on the 6th violated these terms was pointed out to the court in a supplemental filing to return to active docket and invalidate the agreement. On March 12th was the filing. On March 13th, there was a hearing in which the court has the transcripts. At that March 13th hearing, the defendants argued repeatedly about the lack of authority under the operating agreement and the revised code for the manager to be able to come up with an agreement. Secondly, the court on the 6th, December 6th, did not inquire of the manager or anybody on behalf of the defendant as to their acquiescence to the terms, although the court did inquire of the plaintiff's individual parties and not just their attorneys. Also, there were negotiations which were occurring on the record. If you read the December 6th transcripts, of which there was no acquiescence or indication or questioning of whether or not the defendant was in agreement with those terms. One of those terms is this, is the as designees, where the properties can be transferred to designees of the plaintiffs. And that in and of itself is problematic, has been problematic, as the ability to be able to transfer from someone who would receive under a lawsuit and essentially skip them and transfer to designees, is questionable. Also, as we addressed in our first assignment of error, there are properties being transferred which are subject to the statute of frauds. There was no inquiry which was done during December 6th as to the mortgages. We know that everyone in this case is aware that there were mortgages on the properties, specifically because there was a restriction against further mortgages placed on the defendant in August of 2017, and then there was an approval of a mortgage for 1937 4th Street, which was an order that everybody agreed to as of September 2017. So it was evident to, at least should have been evident to the judge, should have been evident to all of the parties, that when we are transferring properties that are subject to encumbrances, that as is would still leave those properties in the name of the defendant. So to transfer 17 properties to the plaintiffs when there's mortgages involved absolutely violates that statute of frauds. The reason we do the statute of frauds is to make sure that we can tie up all of those loose ends, especially as to liens and encumbrances, and put all of these things in writing. Your Honor, some other things as to material terms, there were, they attempted to bind non-parties. There were members of the LLC that were being attempted to be bound, such as Renee Cowan, who was one of the sisters, such as Craig Santomauro, which is one of the brothers. There were provisions on December 6th that looked to bind them and to have mutual releases which were given. There were also some other discussions which some non-parties in the name of Timothy and Blake Madden had agreed to some aspects as they pertain to Sums' counterclaim, and those things were put on the record. When Sums filed their opposition to the proposed entries in February, and then again in the motion to invalidate the settlement agreement and return to active docket, they pointed to the court that it did not have jurisdiction over the probate court case. It did not have jurisdiction over these third parties and had no jurisdiction to bind them. That was fully explained to the court on the March 13th hearing. At that time, the court had not allowed another witness to testify as to the LLC and the powers and the binding of the third parties. When we did receive the proposed agreement on April 10th, or about April 10th from opposing counsel, it had stripped from what had been the other proposed agreements many of the terms in relation to these third parties. Part of the reason why it had done so is when the judge had issued his decision on March 28th, he also had stripped what he previously had deemed material terms, which concerned the third parties, which were a part of what would have been the meeting of the minds and the benefit of the bargain. Those were also stripped from the judge's decision. So consequently, when the April 18th final proposed order, which we appeal from today, was filed, it did not include many of these scrubbed terms, which defendants had argued the reason why it wasn't a valid agreement was because these terms were included and these terms would have been material. When those terms were scrubbed out, consequently the counterclaim of the defendant was also purged because the counterclaim negotiations dealt with a third party, which meant that the defendants did not realize their benefit of the bargain, if you will, or any remedies under their counterclaim as a result of that April 18 order. That was objected to on the record, and still the judge signed the April 18 order in its entirety as submitted by the plaintiffs. We are asking the court to reverse that order, to also find that there was no purported agreement on December 6th, that the attorney did not have the authority to make that agreement. He was not cloaked with authority, nor was there a meeting of the minds, and there were ambiguous terms. Thank you.
Good morning, Your Honors. May it please this most honorable court, I'm Attorney Colin Meeker, and I represent the appellee, Marsha Santomauro. Your Honors, in 2015, in a case called App versus Summit Automotive, this court held that the law highly favors settlement agreements. And there's many reasons that they highly favor settlement agreements, including it resolves the litigation, contains the costs, it alleviates an overcrowded docket, and a victim finally receives their bargain for consideration. In that same case in App, the court held that because the settlement agreement constitutes a binding contract, a trial court can enforce that agreement. And the trial court's enforcement of that agreement will not be reversed where the record contains some reliable, credible, competent evidence in favor of the settlement agreement. And here, binding agreement was made on December 6, 2017. And of course, a binding agreement must contain essential terms. The appellant failed to identify a few of those essential terms. I'll do that for you. Judge Kimbler also identified those essential terms. The transferring of the 17 lots to the plaintiffs or their designees. I note that in the appellant's brief, the issue of transferring to designees was not briefed. The assigning of any leases to those 17 lots. The transfer of any security deposits for those rental agreements. And then finally, the transferring of plaintiff's membership interests back into the LLC. Those were the four essential terms that Judge Kimbler identified. And based on those terms, we feel that those terms are completely clear and unambiguous. And finally, the last thing I would note, an oral settlement agreement voluntarily entered into by the parties in the presence of the court constitutes a binding settlement agreement. And I'd reserve the remainder of the appellee's time so that Mr. Reed can address the court.
Thank you.
Yeah, please, the court. My name is Orville Reed, and I'm one of the attorneys representing. I represent Lisa Madden. Mr. Meeker's office represents Marsha Santomauro, both in plaintiffs and appellees in this particular matter. I would like to draw the court's attention to a mistake that we made in our brief, and that is on page 16 of our brief, appellee's brief, on behalf of Lisa Madden. And if the court would look down at the last quotation that appears there on the page, and it's taken from the case of Thomas versus Thomas. And there was a reference in line 2 to sums. And I believe sums probably should have been in a bracket. Sums was not part of the Thomas versus Thomas case. And the word actually should be appellee that was there. And I'm hoping that the word sums was in brackets and somehow it got lost in one of the many transformations. If it wasn't, I will go back to the office and promptly fire my secretary if this was correct. So I apologize for that oversight. But what that...
I don't think that happened.
Thank you, Daughter. And she thanks you as well. I take full responsibility. That mistake, though, took me back to the Thomas decision to find out exactly how sums showed up in the Thomas quote. In doing so, I note that, of course, Thomas, while it comes from a rival appellate jurisdiction, does cite to an opinion from this court, Booza, which was decided by Judge Mahoney a year year before Thomas was decided. But the Thomas case states thusly. We find that while appellant may have reluctantly entered into the settlement agreement, it was still voluntary on his part and was with full knowledge of the terms of the agreement entered into, and that he was present at the time they were read into the record and adopted by the court. There is a difference between an extrajudicial settlement and a settlement made in open court. The settlement hearing was made before the court, and the court adopted the settlement as its judgment as to division of property and alimony. It was, of course, a divorce case, and that's found on page of the Thomas decision. It's on page 5 of the Westlaw version. Clearly, Your Honors, this was there was reluctance on the part of the defendant. Clearly, they entered into this agreement. The case pended for 4 years, and it involved, or rather like the Thomas case, it involved a divorce of siblings who were involved in the business. The fact of the matter is, the settlement could have been made at any time. It took 4 years to effectuate this settlement. So there's no question about the fact that there was reluctance on the part of the defendant to give his siblings anything. I get that. But the fact of the matter is, this was a decision that was made by the defendant that day. And it was read into the record, not by anybody. It was read into the record by his lead counsel. On that day, the defendant was represented by 3 excellent attorneys, Mr. Souls, his associate Kara Dodson, and Michael Callahan. He had a 4th lawyer who represented him personally, that was Joseph Gorman. And it is difficult to believe that, in fact, these lawyers would have trampled his rights and made him do something that he absolutely did not want to do, or that he was cognitively or neurologically incapable of doing. So I would respectfully submit to the court that agreements, often settlement agreements, are made reluctantly, but there is nothing about this case that should vitiate this settlement. I would point out to the court that as I am in more than the twilight of my career, I am near the midnight hour of my career, and that oftentimes I have walked out of a courtroom and a judge would say, should we put this agreement in writing? And so many times I've walked out and said, there's no need to do that. On this particular day, thank goodness it was on the record. It is spelled out with great specificity for the court. All of the details are there. All of the essential terms are there. And while it can be nitpicked perhaps by a metaphysician, the fact of the matter is it is clear, it is absolutely precise, and in fact it should be accepted as the judgment of this court. You should affirm the judgment of the lower court. Thank you very much, Your Honors.
Thank you. You have 4 minutes.
Thank you. Your Honor, there was a few things that were addressed in the appellee's arguments that I think first we must point out to the court. First, you have the transcripts from the December 6th proceeding. Mr. Gorman was not present. And I think one of the things that Attorney Reed had indicated was he, as in how many attorneys that Mr. Santomauro, Christopher Santomauro as the manager, had at his disposal. Christopher Santomauro is not individually named in this case. He is not the defendant in the case. The defendant is the company. And so that means that the court needed to look at the defendant as a company and needed to make sure that it inquired of the manager. But as far as the company had attorneys, Mr. Santomauro did not have any attorney that was there present as it was being read into the record. There's a few other things that I wanted to add. First, I understand that the appellee's argument is that there was a meeting of the minds and that they wanted the court to uphold the decision of April 18th. But the appellees also had filed with this court a request to remand for a 60B motion to vacate. That was filed in this case under this Court of Appeals, which was denied. There would mean then that there are some issues with that April 18th order that put this purported settlement agreement in record if one of the plaintiffs themselves filed that 60B motion. The other thing I also want to address is that On March 13th, where there was a hearing, there was a pre-hearing supplement that was filed on the 12th. The plaintiffs have yet to actually individually address those issues that were brought up on the 12th as to why there was no meeting of the minds. Just to say there was a meeting of the minds on that day because it was said there was an agreement put on the record isn't enough. I have an excerpt from the transcripts here from December 6th in which the court says,
And that was 2017.
December 6, 2017, thank you, Your Honor. And then the court inquires both of Mr. Meeker as to his client, and on page 13, Mr. Meeker, let me ask you this, as to the terms of Mr. Souls read into the record, does your client agree? Mr. Meeker says yes. On page 9, the court also asked the same of Mr. Reed as to where his client agreed, and he indicates yes. Also, in between that discussion, there were some additional terms in which Bob Souls, who they're looking to say cloaks the defendant, has said, I don't know anything of this. Basically, there were some additional terms that were discussed and addressed, and he said that they had not discussed that before. Clearly, negotiations were still occurring when the purported agreement was put on the record. No inquiry, as was done by the plaintiffs, by the court, was ever done to the manager. No attempt, even though every single person in that room knew of the operating agreement, was there any intent or attempt to make sure that this was in line with the LLC operating agreement or even the LLC Act. And again, as we previously said, Your Honor, it was binding non-parties. Finally, those essential terms that Attorney Meeker referenced as being clear and unambiguous, those were the ones that scrubbed many other terms that were put on the record on December 6, 2017, and that were eliminated after the defendants had explained there was no meeting of the minds due to those terms. We implore the court to please reverse the decision from April 18, 2018, to also find that there was no settlement agreement on December 6, 2017 due to a meeting of the minds, no meeting of the minds on ambiguous terms, and the other reasons that we have outlined in our brief about as to duress and incapacity. Thank you.
Thank you. The court will take the matter under advisement, and we will render a decision, put it in written form, and send it to all parties, and also it will